Swayam Prabha. Digital India. Educated India.
Hello all, welcome to this module on Introduction to Indian Competition Law. So, in continuation with our earlier discussion on the various provisions mentioned in the Indian Competition Act of 2002, we will further take this discussion into the other provisions with respect to competition and intellectual property law. So, in this discussion, we would basically focus on the aspects mentioned regarding the combinations of various enterprises and how the Competition Act of 2002 deals with the regulation of the combination. What are the various provisions and the steps associated with the regulation of the combination. So, in the earlier classes, now we have little bit of idea regarding the anti-competitive agreements, cartels, or the specifically the provisions in the section 3 which talks about the anti-competitive agreements, then section 4 which talks about the abuse of dominant position and the related provisions which are mentioned in those sections regarding those two kinds of practices by the firms or the industries which may lead to anti-competitive environment in the Indian market or the appreciable adverse effect on Indian market. So, basically the nature of any agreement or nature of any combination or any behavior of a firm is determined on the basis whether the activities done by the enterprises is leading to any appreciable adverse effect on the competition in Indian market or not. So, moving forward, so the next important provisions which is mentioned in the Indian Competition Act of 2002 is the regulation of the combination. So, the Indian Competition Act has defined the combination as any acquisition of one or more enterprises or one or more persons or merger or amalgamation of enterprises will be regarded as the combination of such enterprises or the persons or the firms. So, when there are mergers or amalgamation between two or more persons or enterprises or in simpler terms or firms. So, it is regarded as the combination of the firm, or a big company may acquire a small company. So, that is a kind of acquisition. So, that is also a kind of combination. So, the combination can happen between two companies maybe of different sizes, a small company, big companies, and maybe any other nature, more than two firms also may come together to create a combination. So, particularly the section 5 gives us various provisions, or it lays down the threshold level, means under till what limit the combination are free or exempted from the anti-competitive practices or will not come into the eyes of Competition Commission of India. So, basically like if the company is having a market share of 1000 rupees crore or a total turnover of suppose 3000 crore of rupees, then and it enters into any combination, then obviously it has to give information to the Competition Commission of India before entering into any such combination. So, basically section 5 had laid down the threshold levels for different kinds of company operating in India or outside, where the combination may come into the scrutiny of Competition Commission of the India. So, if you look into the nature of the combination, basically the combination can be defined or divided into two main categories. First, the horizontal combination and the second is the non-horizontal combination. So, similar to the horizontal agreements, the horizontal combination is basically the merger or the amalgamation of two companies operating in the same level of the supply chain, or two companies which are producing similar goods, or two companies which are providing similar services, or two companies nearly of same size, and the products are mainly, we can say, substitutable. So, if the two companies are producing substitutable products and the two companies are competitor per se, so then the kind of if they enter into any kind of joint venture, or not joint venture but combination, they come together and merge into a single entity, then it would be a kind of horizontal combination. So, in horizontal combination, one of the drawbacks we may say is the reduction in the competition, because the two substitutable products are now being combined, and so the final combination form which will emerge will have the total monopoly over the substitutable product. So, there may be our chances of price increasing, and so because all these technologies and innovations regarding that product will be under control of such form, then it may lead to reduction in the innovation or product innovation also. And there are other side effects, like there may be reduction in the employment status, because there may be a staff cut off because the two big companies has emerged. So, all these come under the horizontal combination, and it has a high chances that it may lead to anti-competitive environment in the Indian market. So, it is a so this type of combination is particularly important from the view of competition law. The second category of the combination, which is known as the non-horizontal combination, it is again can be classified, it can be classified again to vertical combination or conglomerate combination. So, the vertical combination are particularly combination between the firms or the enterprises which are operating at different strata of the supply chain, or at different levels. But it is not in the true sense reducing the competition, but also the such kind of combination results in more product efficiency or process efficiency, because suppose there is a company A which is into manufacturing of final machinery, and there are company B which supplies the spare parts or the parts related with the machinery. So, amalgamation or merger between these two company may lead to process efficiency. So, one way it is good, people will may get cheaper product by this process, but again there are chances of anti-competitive, in the sense the nature, depending on the nature of this, how technology has been procured, or how technology will be suppressed, or further innovation will happen. So, again more reasoning analysis is required to understand such kind of a vertical combination. And the next one is the conglomerate combination, where two very different kind of two or more very different kind of companies or firms come together and give rise to a combination. So, there is also chances of the reduced chances of competition, in the sense that a product and a service, they may come together and they may create a monopoly in the relevant market. So, again it also requires the rule of reasoning, or like how the market structure has altered or how the competition has altered. So, for each kind of this combination, now the Competition Commission of India follows different approach by reasoning approaches to understand the nature of the combination and the appreciable adverse effect which the combination may have on the Indian competition market. Basically, the Indian government has like our Competition Act has laid down the various provisions for regulation of this combination, because sometimes what happens, the big companies while when they overtake the small companies, or they like acquire the small companies, they in general overshadow them. Like basically they acquired the small companies in order to take their technology, and the small companies, the other small companies which are operating in the market then have a really tough time to compete with them, because anyway these are the big companies. So, they always try to overshadow them or even swallow them. So, all these combination are very important from the point of view of this competition in the market to provide the consumer with a cheaper and more effective product. So, that is why the competition commission, our competition act of 2002 has different provisions to regulate the kind of combination. So, not all combinations are in the in eyes of competition commission are anti-competitive. So, as I mentioned, the section 5 basically specifies the defined threshold limit. So, if the company is having a certain threshold in terms of their market turnover or the assets, then only it will come under the scrutiny of the competition commission. And per se the competition commission will not look into the commission unless and until it finds that the combination of such person or the enterprise will have may cause or likely to cause an appreciable adverse effect on the competition within the relevant market in India, and if such things happens, then the combination will be considered as void under these provisions of combination under Competition Act. So, section 5 gives the threshold levels for the various combination of the firms or the enterprises, and section 6 lays down the various provisions or the regulation how the combination should be regulated. We will discuss this in coming slides. So, if certain firms or companies they want to enter into a combination, the very first step, if they fall under the limit or the defined threshold level in the as specified in the section 5, then the person or the enterprise who or which propose to enter into a combination should give notice to the Competition Commission of the India within 30 days of approval of such proposal. So, if any two companies or two enterprises decide to enter into combination, they should give the notice to the Competition Commission of India within 30 days of such decision or their approval like their final decision between the company. 30 days prior to 30 days of the approval of the proposal relating to the merger or amalgamation or execution of any agreement of or other documents for such acquisition. So, there it should be notified to the CCI within 30 days. So, this is the first step as specified in the section 6 of the Competition Act. After this thing, no combination shall come into effect until 210 days have passed from the day on which the notice has been given to commission. So, within 30 days, like after the agreement signed between the two enterprises, it should give the notification to CCI within the 30 days of such notification or agreement, and till 210 days have passed from that date of notification, no combination should come into effect. So, this is the time period basically if like it. So, a combination to be approved by the Competition Commission of India takes 210 days. So, minimum time limit for a combination to happen is 210 days if it meets the criteria as laid down in the section 5 of the Competition Act. So, the detailed provision regarding the procedure for investigation of the combination is mentioned in the section 29, 30 and 31 of this Competition Act. So, they have laid down a step by step procedure how the combination should be investigated. So, as per the section 29, when the commission has the prima facie opinion that a combination may cause an appreciable adverse effect on the competition in the relevant markets of India, so it issues a so cause notice to the parties, and the parties are given 30 days of time period to respond, like why there should not be any investigation regarding the combination. So, now as you know, in the Competition Commission of the India, the CCI itself may initiate any investigation, or it may by the information from any other relevant party or person also may initiate an investigation. So, if the CCI has the opinion that some combination may cause an appreciable adverse effect in the markets of India, so it has the power to suo motu start an investigation, and so it gives a notice to the relevant parties to the combination, and then they are given 30 days of time period to respond to their notice, saying the reasons, stating the reasons why there should not be any investigation if they think so. Or then the CCI may directly start the investigation, or the CCI may tell the Director General to initiate an investigation to determine if the combination is causing any appreciable adverse effect, or it does it have any chances of causing. So, it may cause or it is causing. So, these two things has to be considered carefully before combination to be named as an anti-competitive combination. The initial steps are that first, a notice to the parties to the combination. Second, the investigation is initiated by directly through the CCI or through the help of the DG. So, after these, like the 30 days of time period which is given to the parties to respond. So, after the receipt of the response from the parties of the combination, the commission may call for a report from the Director General. So, again, first the commission receives the report or the response from the parties and also reports from the Director General. So, within receipt of such report, within 7 working days, the Director General receipt of report from the Director General, and then within 7 days, then the CCI directs the parties of the said combination to publish all the relevant details of that combination within 10 days. So, the from the response, after the response and report from the Director General, CCI asks the parties to publish the details of the combination agreement to the public, so that it would be like in the public domain to understand the very nature of the combination. Now, so once it has been published, like 10 days has been given, the commission has the power to also ask for individual assessment, or the ask from the members of the public or affected persons, or which maybe the affected parties which have higher chance of getting affected from this kind of combination, to file their written objection within 15 working days from the date on which the details of the combinations were published. So, once the parties publish the detailed combination agreement, detailed of the combination agreement in the public domain, the CCI, if he thinks fit, may ask for the third party objections, maybe from the affected parties or from general public, to raise their objections, and they may be given an additional time period of 15 days to file such an objection. And once the CCI receives such objections from the third parties, then it should deal with the cases within 45 days. And then finally, within 45 days it starts dealing with the cases, and it has the certain time, it may be extended in some, depending on the complexity of the cases, sometimes the time period is also extended. So, if the commission does not pass any order within 210 days of the date of the notice to the parties, then the combination shall be deemed to be approved by the commission. So, if no information is, then it is a good information and the combination can be thought of approved. So, this is the basic steps which has been laid down in the section 29 of the Competition Act of 2002, like how the Competition Commission of India is Competition Commission of India analyzes the combination agreements. So, one of the important features of this combination agreement is that not only the combination agreements happening in India is being scrutinized or can be investigated by the CCI. Sometimes if any of the party is not residing in the India, or any of these enterprises which may be dominant is residing outside India, can also be investigated. So, the CCI has the power to investigate all the agreements, not only combination, all the anti-competitive agreements or abuse of dominant position kind of agreement, even though the parties are not residing in the India. So, basically if we look into section 32 of this Competition Act. So, it says that the commission shall have power to inquire about the appreciable adverse effect on competition in India, notwithstanding that an agreement referred to in section 3 has been entered into outside India, or any party to such agreement is outside India, or any enterprising abusing the dominant position is outside the India, or a combination has taken place outside the India, or any party to combination is outside to India, or any other matter or practices or action arising out of such agreement or dominant position or combination is outside India. So, whenever there is certain kind of agreement which is affecting the competition in India, irrespective of the location, geographical location of the parties to this combination or agreements or abuse of dominant position, then the CCI has the power to investigate into all those matters. So, this is very important with respect to competition in market, because nowadays like more than 200 countries have adopted the competition provisions in their laws. So, it is very important to maintain the competitiveness among the companies in India to have an effective or a productive market in any of the country. So, again so far we have discussed about the various anti-competitive provisions which are laid down in the Competition Act, like section 3 all about the anti-competitive agreement, then section 3 subsection 5 which tells about the exemption to this thing when the IP is involved, what kind of, like if certain intellectual property rights are in place, then there are certain exemptions given to the company. Section 4 is all about the abuse of dominant position, and section 5 and 6 talks about the combination agreements and the various procedure associated with it. Then you have also seen how the Competition Commission of India deals with the cases or takes into account the various questions to understand what is the appreciable adverse effect on the competition. So, again so we have so after this, like I would like to shed a light on this competition advocacy, which is one of the important provision laid down in the Competition Act of India, one of the important as well as one of the unique provisions. Like, so the section 49 particularly tells about the competition advocacy. So, what is this competition advocacy? So, now like as you know, the MRTP Act was repealed, then this Competition Act was is in force since 2000 and like it came in it was passed in 2002, but came into force in 2009. So, one of the important provisions is laid is that competition advocacy, which is basically promoting of the very nature of the competitive means competition law, to create an awareness among the companies or masses about this competition law provisions. And apart from this, so as per the section 49, the central government and the state government, while formulating any policy on competition matter or while reviewing any laws per se, should take the opinion from the Competition Commission of the India, because any modification or changes in any law or policy might have certain implication on the competition within India. So, before making any changes to the competition related laws or any law other than competition law also, they should take a opinion from the Competition Commission of the India. And the competition, once requested, the Competition Commission of India will give its opinion within 60 days of such request. And but this is not binding in nature. So, the opinion like it is not binding on the central government or state government, it may take into consideration such consideration. And the third provisions which is laid down in section 49 is that the commission shall take suitable measures for the promotion of the competition advocacy, creating awareness and imparting training among regarding the various competition issues. So, basically it is to like, because like this is very new in to the practice of new in India per se, in the Competition Act. So, that time, so it is thought that the competition advocacy is one of the important provision which should be propagated to all the stakeholders of this of any transaction. So, competition advocacy remains one of the unique feature of the Competition Act of 2002. Now, there is a so the once the competition commission reviews any kind of agreement, whether it's a horizontal or a vertical, maybe a cartel, merger, amalgamation. So now the competition commission issues this decision, so the decision may be if it finds the the agreement to be anti-competitive, so it may abort the agreement, or if it thinks that the appreciable adverse effect, like it may cause appreciable adverse effect, and which can be changed or which can be prevented by certain modification in the agreement clauses, then also it may suggest that, or it may change the it may ask the companies to change certain criteria in the agreements. So, depending on the nature of the final decision, the companies should abide by the decision made by the Competition Commission to India. So, if the companies or the parties to the agreement or the combination do not abide by the final decision of this director CCI and director general, then they are generally penalized. So, if the person fails to comply without reasonable cause to the direction given by the commission or the direction given by the director general, while while exercising their power by virtue of the subsection 2 of section 41, such person shall be punishable with the fine, which may extend to rupees 1 lakh for each day, during which such failure continues to subject of maximum rupees of 1 crore. So, a company may be fined for by the amount of 1 lakh rupees per day to the maximum cap of rupees 1 crore, as may be determined by the competition. So, again there are this is like they basically the penalty is decided depending on how much profit is company making, how much share or asset is the company is having. So, the Competition Commission takes all these financial matters into account and decides the amount of fine which has been, or the amount of penalty which has been given to the companies. And even when the first notice was given to the parties to the combination, so and after the report from the DG, the Competition Commission asked the companies to publish all their relevant information on the public domain. So, if the parties to the combination does not furnish the information on the combination, it is also a for that reason also they can be penalized, and the penalty may extend into to 1% of the total turnover of the assets, or whichever of the higher of such combination. So, it is also an essential requirement that the companies should abide by all the rules or the procedures laid down in the Competition Act of the India. And also there is also penalty for making false statement or omission to furnish material information. So, if some companies furnishes certain false statement or do not furnish complete information, then also it may be given a penalty of rupees 50 lakhs, and it may also extend to rupees 1 crore as determined by the commission. So, basically the commission can give penalty for any of these cartels or the anti-competitive agreements in the form of the cartels. Basically there are 4 kind of effect which a cartels or which any combination or agreement may have, as laid down in the section 27. So, the commission has the power to pass any order, like commission may pass the orders if by directing the parties to discontinue and not to enter such agreements. So, the commission if thinks that appreciable adverse effect is visible, it may direct the parties to discontinue or not to enter into such kind of agreements, or it can ask the parties to modify the agreements, or it can ask the parties to abide by the orders of the commission and comply with the direction, including the payment of costs, and may issue certain other direction as deemed fit for the situations. So, the CCI and the DG has these powers to direct the parties to regarding change or modify or even cancel the agreements. Again, one of the important provisions in Competition Act of India is the leniency program. As we have also seen in the European Union, there is the whistleblower immunity. Similarly, in line with that European thing also, in India we have a provision called the leniency provision. So, basically this leniency program has been started to incentivize the cartel members to come forward and share the secret information, so that the commission can investigate the matter in a better way. So, as you know, this cartel, particularly cartels or the anti-competitive agreements, is a kind of a secrecy agreement. So, it is very difficult to get any substantial proof to establish that there is a cartel ongoing and it is affecting the price or the market structure or the competition. So, in order to get more relevant information, the Competition Commission, the Competition Act has included this leniency provision in the year 2009. In the amendment of 2009, these provisions has been added. Initial like in 2002 Act, it was not there. So, basically it tries to incentivize the cartel members to come forward. Not only cartel members, by any third parties also can come forward, and if it has certain information, it can give to the Competition Commission of India, and for that there are confidentiality provision as well as the incentive provision. So, it is a kind of whistleblower protection, and it encourages and incentivizes the actors of the competition infringement to disclose the anti-competitive agreements in lieu of immunity or leniency treatment. So, the leniency treatment is basically in the in terms of the reduction in the penalty, or confidentiality clauses also is there, but still like the main attraction is the reduction in the penalty. The penalty waiver can be as much as up to 100%, or depending on the nature or type of this disclosure, it may again vary, like maybe 100%, 70%, 30%, depends like at what stages the information is given and how relevant are those information. So, basically the leniency program covers the infringement which directly or indirectly determines the purchase of the sale price, then limits the control or production, supply, market, technical development, investment provisions or the services, or it those kind of infringements which share the market or the source of production, provision of services by allocation of the geographical area or type of goods or services, number of customer allocation, market share allocations, geographical region allocation. So, if any kind of agreement is covering those things, is also can be like the whistleblower immunity or the leniency provisions can be applied there also, or the bid rigging provisions, collusive tendering, these are also those are also coming under the purview of the leniency scope. So, basically all this cartelization, anti-competitive agreements can be a part of leniency program. So, basically, and the section 46 particularly gives the power to impose the lesser penalty. So, the lesser penalty shall be imposed by the commission only in respect of a producer, seller, distributor, trader or service provider included in the cartel, and cartel who has made the full, true and valid disclosure. So, these three are very important. So, the disclosure should be complete, true and vital. So, non-relevant information cannot be considered as a vital information, and for that reason a company or this whistleblower cannot be provided the immunity. So, this immunity is not applicable if the disclosure is made after the investigation has been published. So, now we have learned that the Competition Commission of India adopt certain steps to understand the very nature of this agreement. So, if certain companies makes the disclosure after the commission has initiated initiated a discussion and the final report has been published, in that case the leniency will not be applicable, or it is not applicable, it is not if it is not complied by the regulation and it has given false evidence, the evidences are not true in the sense related to the agreement, and the disclosures are non-vital. So, in those cases a company cannot a company or the producer, seller, distributor cannot ask for the leniency provision. So, as I was discussing, the quantum of immunity may be like 100% for the 100% of the fine for the first applicant revealing the vital information. So, it is the first come first service type of thing, but again those other parties which may come forward after the first one, maybe the second or the third parties, can also get a reduction up to 50% or 30%. So, the first one coming for the disclosure gets a higher reduction in the penalty, and then subsequently the percentage decreases. And one of the important thing that if some company wants that its name should be kept confidential, that kind of provision is also available in the leniency provision. So, this is all about the combination agreement and the basic provisions laid down in the Indian Competition Act. So, now we have learned the very nature like section 3, section 4, 5, 6 particularly, and the related procedural section related to that, and the leniency provision. So, so this is to give us a basic idea what the Competition Act of India covers all about. But now coming to the next section, like we will discuss how the agreements related to intellectual property rights are looked in the purview of Indian Competition Act, and how these sections are applicable or relevant in the case of the intellectual property related agreements. So, before that, like the just a few more things were there, like there are so far there have been only 5 decisions on which the leniency provisions has been applied. 5 cases are there. So, the first one to get a leniency decision by the Competition Commission of India is the brushless DC fan, which the a case in 2014, where the Director General has initiated the investigation by the input from the CBI. So, as per this report, the report suggested a cartelization between the manufacturers and the suppliers of the brushless fans in relation to the tenders floated by the Indian Railways and Bharat Earth Movers Limited for the supply of the brushless fans and other electrical items. So, the CBI gave an input to Competition Commission, and after that the investigation is started by Director General. So, so they found there is certain cartel type of structure is going on for these tenders of the brushless fan, and then during that investigation one of the parties applied for the leniency. So, in the final decision of this case, the CCI has acknowledged that the disclosures made by the applicant were very significant, and it has added value to determination on the existence of the cartel. So, the information were really vital for the case, and for that reason the complete immunity immunity was granted, but complete immunity was not granted, since the case investigation has started by the time when the party has come forward to disclose the information. So, that is why in this case particularly the reduction in the penalty was kept to 75% of the fine. So, this is the first case where leniency provision were adopted. The second case was the zinc carbon dry cell battery case of 2016. So, here the leniency application was filed by the battery company Panasonic Energy India Limited, where it gave the information to the CCI into the cartelization of the dry cell batteries between Panasonic, the Eveready Industries or the Eveready Batteries company, and the Indo National or the Nippo companies. And subsequently the association of the dry cell manufacturers of the manufacturers, where these 3 companies were are the members, was also included within the scope of the investigation. So, after this input from Panasonic, the Director General has conducted search and seizures operation in the premises of all these 3 companies, and they have looked into their communications, emails to understand the nature of the cartelization. So, for this reason the CCI has given full immunity to Panasonic from the administrative penalties, like 100% reduction in the fees, and it was the first because this is the first information the given by the Panasonic has led CCI to investigate into this matter and find out the existence of the cartel. And secondly, the after Panasonic, Eveready and Nippo has also come forward for the leniency thing, and they were granted 30% and 20% immunity respectively for their cooperation in the cases. The third one was the one of the cases is the related to the Pune Municipal Corporation, where the waste management regarding some waste management. So, in this case also the investigation was initiated on the basis of an information by Nagrik Chetna Manch, which alleged that there is a bid rigging process going on between 6 parties in the tenders issued by the Pune Municipal Corporation for the municipal organic and inorganic solid waste processing plants. So, initially during this investigation, one applicant filed for the leniency, and subsequently the 5 other parties has also filed for the leniency at different stages of the investigation. The parties at the outset raised certain issues, they raised certain issues regarding the confidentiality of the of their very disclosure or the nature of the statements they made. So, they have asked for the confidentiality thing, so they not to reveal their name and not to reveal what kind of information they are disclosing, and during regarding which the CCI explained that the confidentiality granted under the lesser penalty regulation did not extend to the evidence collected by the DG as a part of the evidence. Their names can be kept as confidential, but not the evidences. It should, because evidences are the prima facie thing on which the judgment will be given. So, the evidences cannot be kept confidential, even though it is obtained by a leniency applicant. So, further it held that unless directed otherwise by the CCI, the proceedings are not open to public, including the contents of the DG investigation. So, the DG's investigation reports are not public unless and until CCI decides to make it public. So, these things were made clear to the leniency applicants, and so full immunity was not granted to the 6 leniency applicants that has approached. However, penalty were reduced, and based on this information, the CCI has also further investigated into 2 more cases, 2 more tenders. So, the cases were another was in 2016, where also the CCI received a leniency application by one of the parties, and then followed by 2 other. So, out of these 4 applicants, 50% was granted to the first applicant, 50% leniency was granted to the first applicant, and another case was investigated in 2016, same year 2016. And the CCI did not levy any penalty on the parties in consideration of the fact that the penalty has already been given in any related cases in the earlier cases. So, these are the 5 cases which are given the in which the leniency provision has been applied. So, this basically helps the parties to come forward and to reveal the information, so that the Competition Commission can investigate into the matter in a better way. So, this is a very important provision to understand, to maintain a good competitive environment in the Indian market. So, with this we complete this module on the basic provisions of Indian Competition Act. Now, in the ongoing sections, in the upcoming sections, we will deal about the various licensing agreements and how the interface of IP and competition law are dealt in India. So, thank you very much.